Hi, I'm Kimberlee Stafford. I'm a partner in the Real Estate and Land Use Practice Group at Tonkon Torp, a Portland-based business law firm. Today, we're going to talk about the basics of commercial real estate due diligence. When you're purchasing a piece of commercial real estate, you need time to inspect it and otherwise make sure that it's in the condition you expect for the purchase price you are paying. This is called due diligence, and most purchase and sale agreements are negotiated such that the buyer has time to conduct due diligence to make sure the property is satisfactory before the buyer is obligated to buy the property. I'm going to talk about three aspects of due diligence. First, the physical inspection, including environmental assessments. Second, title and survey review. And third, review of the seller's documents. For most commercial properties, a buyer will want inspection of the roof and the mechanical systems, i.e. the heating, ventilation, and air conditioning. These are the big ticket items when they need to be replaced. So buyers will want to understand how much useful life is left in them before they buy the property. Additionally, we recommend that all commercial buyers have an environmental consultant perform a Phase 1 environmental site assessment. A Phase 1 consists of a site inspection and a review of historical and environmental records of the site to determine if there are any recognized environmental conditions, or RECs, on the site. A Phase 1 does not include any invasive testing or sampling. If the consultant determines RECs exist, they may recommend additional investigations such as a Phase 2, which does involve testing and sampling. We recommend all buyers conduct a Phase 1 because it is the minimum due diligence that's required for all appropriate inquiry, which is required for certain safe harbors under the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA. The purpose of title review is to make sure there are no encumbrances, restrictions, or easements recorded against the property which would limit or prohibit the property's use for the purposes for which the buyer is buying the property. Examples would be a tax or judgment liens encumbering the property that reduce its value, or a restrictive covenant that prohibits the use the buyer wants to use it for. For example, a restriction on having animals on the property when the buyer wants to use it as a veterinary hospital. Also, whether there is legal access to and from the property, or whether someone else has an easement over the property in an area the buyer was planning to use for something else. If there are title matters to which the buyer objects, the purchase and sale agreement usually provides for a method by which the seller must cure the title defects, or the buyer may terminate the agreement. This leads us to whether you want to have a survey done. If you are financing the property, this question may be answered by your lender, since most lenders require what's called an ALTA survey to be done on the property, which is a type of survey with specific standards instituted by the American Land Title Association. However, if you plan to develop or redevelop the property, you'll want to have a survey to locate easements and other matters of record to make sure they don't interfere with the development plans. And if existing improvements on the subject property or on adjoining property are near the property boundary line, you may wish to conduct a survey to confirm whether or not any encroachments exist. The last major aspect of real estate due diligence involves the review of the seller's documents relating to the ownership and operation of the property. The buyer will want the seller to provide copies of all existing surveys, environmental reports, title reports, and other reports concerning the property, service contracts regarding the operation of the property, leases for any current tenants, and the most recent property tax statements and operating budgets. Existing surveys and title policies and environmental reports give the buyer an idea of the property condition pending receipt of the result of the buyer's own surveys, inspections, and title review. Review of the service contracts helps paint a picture of what is needed for the operation of the property. The buyer will also need to decide whether these contracts should be terminated or assigned to the buyer at closing. Review of existing leases is imperative. You'll want to understand the economics of the leases, the term of the lease, rent and periodic escalations, what costs are passed through to the tenant, and who is responsible for maintenance. Also, if the tenant has any rights to expand into additional premises or any rights to actually purchase the property. The financial statements or operating budgets will give the buyer an idea of the cost to operate the property, and if they show reserves, they may give the buyer a good idea of what capital improvements may be needed in the near term. So we've talked about the basics of commercial real estate due diligence, including physical inspections, title review and surveys, and review of the seller's documents. But this has just been a basic overview. If you have further questions, please reach out to any one of us in the Real Estate and Land Use Practice Group at Tonkon Torp, or visit us at tonkon.com.